Hello, everyone. As promised, we are going to discuss the warrant issues brought up by Bishop Whitehead in his interview with Tasha K. Well, let's just start with this. He's not even saying that he didn't do it. He didn't even say there wasn't any evidence against him. He is challenging all the procedural, basically the processes that were used to obtain the evidence and saying that it was obtained unlawfully or the processes weren't followed where his lawyer didn't get all the information that they should have gotten and all the evidence they should have gotten in a timely fashion. That's what he's challenging. I just don't, but all this stuff can really be debunked. So what we're gonna do is he's exhausted all his state law claims. He's all his state claims, he's already exhausted them. So now the only thing that he had left was to do a habeas petition, which I believe he did maybe in 2012. So we're gonna go on the habeas petition where he raised these same arguments. That's why I don't understand why he's saying, well, it's the process and it goes so slow. What are you even talking about? You raised all these claims already and you were denied. But let's go over the habeas petition so that we can get a better understanding because the way he presented this, it was inaccurate and it was very confusing. So let's try to unravel what he said. So this is an opinion from his habeas petition. Like I said, he had already exhausted all of his state law claims, so he filed a petition with the federal court, and he basically challenged his conviction under the Fifth Amendment, the Sixth Amendment, and the 14th Amendment. And what his claims were is that the trial lawyer was ineffective and that the court improperly admitted evidence of uncharged crimes and a witness's unsworn testimony. So those were the substantive arguments that he raised in federal court. So when you go through, of course, you have the factual background in any opinion, but I think it's we must go over what each attorney did in this case. So as he said, he fired he fired 3 attorneys. He had 4 attorneys. So that's your first red flag. Typically, when somebody goes through all those attorneys, they are considered a difficult client. That's typical that's what occurs. And it seems like that may be the problem in this case. So let's go to some of the procedures. So we all know he said what his charges were in the video. So we already know what his charges were. He was indicted. He was convicted of 17 counts, something involving theft and um, other financial related crimes. It looks like. So what happened is he had the first attorney. We'll call him attorney one. When attorney one got on board, he did what all attorneys do. You ask for discovery. That means all the information that you have that you want. So his attorney filed a discovery motion seeking the search warrants that were issued against the bishop, the affidavits and the returns thereof, also property that they may have seized. And as you see, this is documented here, the stuff that he asked for. Now, the assistant DA at that time responded that the people, which is the state, were in possession of 3 cell phones and 1 vehicle, but he did not address the laptop or the warrants. He basically said that it's beyond the scope of discovery, which really isn't true. He probably should have submitted it to him, but he didn't submit it to him. So lawyer number one ends up gone, and well, the DA later supersedes the indictment and adds more counts. So then Bishop Whitehead fires him. So then here comes lawyer two. Lawyer two thought that the evidence was limited, according to this document, according to what Bishop Whitehead alleges, that the evidence based on what was produced when the first lawyer requested discovery, that the information they have, it's not that much or whatever. So I guess he thought he was like in the clear, that they're going to end up dismissing this case. And I guess he relayed that that's what his lawyer told him, that they don't have much evidence, they're going to end up dismissing this case. Lawyer number two was offered after the superseding indictment. The ADA supplemented some of the discovery, but he added like voice recordings or something of that nature, gave his second attorney the ability to come to the ADA's office and to look at all the evidence that they had. However, he again did not produce any affidavits of the warrants either. But what he did do is allow them access to the actual information, the actual stuff that would have been in that warrant that would have been listed. Okay. So then she files a motion just generally trying to exclude all the evidence because she felt like they produced it late and it should have been produced with the first lawyer. So that was pretty much her argument. Whatever evidence you're trying to give us now, it's too late. We about to go to trial and you should have gave that to the first lawyer. Well, the judge was like, no, and denied their motion. So after that, she ended up getting fired. So now you got the third lawyer. So the third lawyer, I believe the indictment was superseded again, and that's when you have the 57 counts. And with the 57 counts, they did produce that affidavit to her, but apparently she didn't tell nobody once she got that affidavit of the warrant. Okay. Now let me back up a little bit. I believe with lawyer number 2, yes, with lawyer number 2, the DA offered a plea deal. But because lawyer number 2 didn't think the information was a whole lot of information that they had against them, according to the bishop, she didn't advise him that he should take the plea deal. So the plea deal was, we are going to drop all of the counts and you just plead to one and you do a year in prison. Okay, that would have been the plea deal, of which the bishop declined. So let's fast forward. I said the third lawyer. Now you notice in his interview, he said that nobody ever got these affidavits. Well, according to this document, this opinion from the court, the third lawyer did get this affidavit of warrant. However, just the bishop didn't know about it. So he had a fourth lawyer, and the fourth lawyer is alleging that he didn't have any of this information before and that the third lawyer never gave him the affidavit. So this is how all this affidavit of warrant, it's all a procedural issue that the bishop is alleging in this interview of why he believes he should be exonerated. So let's go down so we can go specifically on what was alleged. Let's go to the ineffective assistance of counsel claim. The petitioner claimed that the prosecution's late disclosure of the search warrant affidavits deprived him of the effective assistance of counsel in 3 ways. First, he claims that had the second of his 4 lawyers known the full extent of the material seized pursuant to the warrant, she would have counseled the petitioner to accept the prosecution's offer of a misdemeanor. So essentially what he's saying on this is that had she gotten the affidavit, she would have known we have mountains and mountains of evidence against him. So hey, buddy, you probably should take this deal. And because she didn't have this information, she wasn't able to properly counsel him. So that's why he declined the deal. Well, what I have to say to that is one of the first things that I told my clients is I want to know everything. I want to know the things that you don't even think that the police know, because we have attorney-client privilege and I don't want ambush litigation. I don't want nobody coming at me at the last minute with new evidence like what he is alleging happened here. So it was your duty, sir, to say what you've done in the past or what may come up, because you already know they're surveilling you. You already know they have warrants and subpoena, like they're subpoenaing people, they're finding victims. I mean, come on. And now you're basically saying that because your lawyer didn't know that you would end up having a superseding indictment again because they found more victims, that she's ineffective. Well, the court didn't agree with that analysis and said no, that's denied. So the second, he argued that the third lawyer was ineffective because once she received the search warrant material, she took no action and didn't notify the next lawyer. Okay, well, the court said that she was not ineffective for that. Why? Because the first lawyer already filed the motion that you felt like the second lawyer should have filed, even though the first lawyer did not have the actual affidavit of warrant. She had enough information and she asked to suppress it and the court denied it. So why would the next lawyer come and redo what what the court already denied? So the court said that would have essentially been a waste of time and it wouldn't have made sense. So therefore, that challenge was denied. And then we have that the third was that the second lawyer's shortcomings. The argument went that it tied the hands of the fourth lawyer, who would have argued differently and try to suppress the information or suppress the warrant himself as well. So that was pretty much his arguments on the ineffective assistance of counsel. But the court ultimately denied all that because he said, even though she may not have had the affidavit of the warrant, your attorney did have access to all of the actual physical evidence. So she was not deprived of anything just because she didn't have the paper. So let's go on to all the other warrants claims. So then he says that he was somehow prejudiced. So he claimed that the Teaneck warrant was deficient because Michael Richer and Detective Gabriel, that they both signed warrant applications, but only one of the officers appeared before the magistrate. He also claimed that the detective's affidavit was defective because although it was notarized, it was not dated, and there is no indication that the document was actually sworn to. The court said you cited no case law. You asserted that those alleged discrepancies invalidate the warrant because the affidavit was the sole basis for probable cause, and the submission of a warrant application in Teaneck, New Jersey by a law enforcement officer whose jurisdiction is limited to Suffolk County was improper. Well, the court basically listed a whole bunch of case law and said omissions or accuracies in a warrant do not necessarily require suppression. So that didn't fly. So then he also challenged the manner in which the property was disposed. Remember, he mentioned about all the stuff being in a garbage bag or something, or how they collected it. Well, the court said, and then about the jurisdiction sharing the property or whatever he said. So the court said in its opinion, he argues that the Teaneck warrant directed that the property be maintained by the Teaneck Police Department, but that the police reports and trial testimony indicate that Detective Gabriel took the items to Suffolk County. Okay, so that's what he basically is talking about, the whole taking the property from New Jersey over to New York. Well, the court said, assuming for the sake of argument that the seized property was improperly transferred to Suffolk County, this error would not on its own require suppression of evidence. Both New York and New Jersey courts have held that the technical non-compliance with the return and inventory of provisions of CPL 690.50 sub 5 does not undermine the validity of the search warrant or the search. So that didn't work. Then remember he talked about the stamp. I don't know where this whole somebody stole the judge's stamp and all. I don't know where that came from because that's not in any of these documents. But they did mention a stamp being used or an electronic warrant being used. So the court said, finally, with respect to the electronic warrant, the petitioner does not cite any case law in support of his argument that use of a signature stamp rather than an original signature rendered the search warrant unconstitutional or contrary to statutory law, and this court has not found any. In sum, none of the objections the petitioner raises would have undermined the legality of the warrants. So let's just go to the conclusion. The petition for writ of habeas corpus is denied in its entirety. The case is dismissed. A certificate of appealability will not be issued. So basically, you can't even appeal this because we didn't give you permission to appeal. So there we have it. I hope that I didn't move too fast. I hope you understand everything that I said. I know it's trying to move it, but I want to hear what you have to say. As always, please like, please share, please comment. It's so much that has been going on in this case, and apparently the bishop does not want us to look into anything that he says. He just wants us to take his word for it, which we are not going to do. Like, we don't do that over here at the Law Intellect. We research and we make sure that what you're saying is accurate. But this is something that he did say that I thought was quite interesting. Let me let's see.
My Facebook, Bishop Lamore M. Whitehead. Good guy. So just watch and let everything pan out. Let everything pan out. And it's going to be a time where you're going to say, wow, I know I seen that paper work, but I didn't know it meant it that way. Oh, shoot. Oh, wow. And y'all going to say, Lord, forgive me. Y'all going to say, Lord, forgive me. Charge it to my head and not my heart. But let me get off social media because y'all know that.
So all I'm saying is he still wants us to not believe none of the documents or none of the opinions and take it his word for it that some process has been going on or whatever beyond this, and that he's going to be exonerated on technicalities. But anyway, as always, it was great talking to you guys, and I will holler at you later.